Thank you. Um, are you able to see my slides?
Yes, we can see and we can hear you.
Okay, so I'm going to spend a short time talking about the Patients' Rights Charter, and then we're going to have a panel discussion about aspects of our Kenyan Patients' Rights Charter. So a Patients' Rights Charter is an official document that is prepared by a government or an organization, and it lists the patient's rights and responsibilities. This started off in the UK in 1991. They created a patients' rights charter for patients who are covered under their national NHS, their National Hospital Services. So this document was supposed to help patients to interact with the healthcare system and to help them to improve systems for the patient. And several countries have adopted these charters as we aim for patient-centered care. So a patient rights charter will consist of rights that exist in the law. So it is prepared with the things that already exist. So we look at what the rights are and what the various statutes of government say about the rights that a patient has, and it's consolidated into one document. So some areas of focus include access to healthcare or information, privacy when dealing with the patient, giving informed consent, issues of medical insurance. So basically, it educates the patient about what their rights and responsibilities are. Our Kenyan National Patients' Rights Charter was first developed in 2013 by the Ministry of Health. That is the first edition in October 2013. It has not been reviewed. It's still what we are using. And it has 3 sections. The first section, it defines the patient's rights, and then the patient's responsibilities, and also talks about dispute resolution mechanisms. It's a short document. It just has about 7 pages of content or information. So it's a document that patients can go through, and even as we interact with patients, we need to know what their rights are. So I'm going to just highlight them briefly before we go into the discussion. So this is the way the rights are arranged in the Patient Rights Charter, and each of the rights comes with an explanation of what it means, but I will just go through briefly what the rights are. So the first right is to access healthcare. Then patients have a right to receive emergency treatment in any health facility. They have a right to be informed of all the provisions of their medical scheme or health insurance policy. They have a right to choose their healthcare provider, a right to the highest attainable quality of healthcare products and services, a right to refuse treatment, a right to confidentiality. Then there is right to informed consent to treatment, right to information, a right to be treated with respect and dignity, a right to a second medical opinion, a right to complain, right to receive insurance coverage without discrimination, and the various aspects of discrimination are stipulated, for example, age, pregnancy, disability, illness. Then every individual has a right to donate his or her organs as they may wish, whether they donate these organs while still alive or upon death. Now, with rights come responsibilities, and I think patients need to understand this, that yes, they have rights, but they also have responsibilities that accompany those rights. And the first one is that everyone has a responsibility to take care of his or her health by adopting a healthy lifestyle, a responsibility to adopt a positive attitude towards their health and life, a responsibility to respect the rights of others. So your rights are only as valid as when you respect the rights of other people. It should not infringe on others. They have a responsibility to give healthcare providers relevant and accurate information that will help in their diagnosis and treatment and rehabilitation. They have a responsibility to take care of health records in their possession, a responsibility to keep appointments, responsibility to follow instructions and adhere to and not abuse or misuse prescribed treatments. They also have a responsibility to make appropriate payments for treatment and rehabilitation so that they can receive the treatment, whether the payment is by insurance or cash. Then they need to be aware of the healthcare services in their locality so that they can make an informed choice of where to utilize services. They need to inform their healthcare provider when they wish to donate their organs. Then they have a responsibility to seek treatment at the earliest opportunity and to express any concerns through the right channels confidentially. So sometimes patients are not happy with the service that they get, but they need to express these concerns through the right channels and in a confidential manner. I think in this era of social media, it's becoming a bit difficult because patients complain and they go and post on Twitter, on Facebook, and they tag along the names of the hospitals or the doctors, but they're actually supposed to complain in a confidential manner and resolve disputes in a confidential manner. So we'll look at some of these things more as we have our panel discussion, but the last chapter of our Patient Rights Charter is about dispute resolution. So when a dispute arises between either a patient and a healthcare provider, a patient and their insurance, patient and the employer, or the patient and a regulatory body, they are supposed to address these disputes through 3 recognized channels. And the first one is to deal directly with the person whom they have a dispute with. So they lodge a complaint and try to resolve the dispute amicably. Then they can also pursue their complaints through relevant regulatory authorities such as the Ministry of Health, the Medical Practitioners and Dentists Council, Pharmacy and Poisons Board, Nursing Council, Clinical Officers Council, or whichever regulatory authority will deal with the issue that they're complaining about. And the last channel is they can also lodge a claim through the courts to seek appropriate remedies, but that is as provided under the law. Thank you for listening to that introduction. So now we are going to go into our discussion, and I'm handing it over back to our moderator, Ms. Anne Kirema.
Thank you very much, Dr. Nafula, for that clear and precise introduction. And I don't know whether our participants have had an opportunity to interact with the Patient Charter or even the Act itself that provides for the rights of the patient within the laws of Kenya. I will start the panel discussion, but before then, I would like Mr. Fleming to introduce himself and tell us briefly about himself and what the rights charter means to our clients. And yeah, just briefly tell us something about the charter and what it means legally.
Good afternoon.
Good afternoon.
As you've heard, my name is Fleming Omondi, legal officer at Kenyatta National Hospital, an advocate of the High Court of Kenya. Now, when I was invited to be one of the panelists, especially to interrogate what patient rights charter means to the patient and perhaps maybe the healthcare service provider, I sought solace in the fundamental human rights as guaranteed by the Constitution of Kenya. Now, the health service provision is now looking at the human rights approach, which most of them you have been taken through in a nutshell by Dr. Nafula. Now, stemming from the constitutional perspective, which guarantees that every person has the right to the highest attainable health standards, which then also include the rights to healthcare services, which includes the reproductive healthcare services as well, among other services that you provide as healthcare service providers, including the emergency medical treatment. Now, all this from a constitutional perspective and also from the perspective of international and regional human instruments such as the International Convention of Economic and Social Cultural Rights and African Charter of Human Rights are both ratified by Kenya. So to meet these particular obligations that is put on the country, both locally and internationally, in relation to healthcare per se, Kenya has had to take a lot of legislative and policy and other measures, including setting standards as contained in the Patients' Rights Charter to ensure that progressively we achieve the rights to health. So to me, it means a lot to the patient because it accords them rights. But even where there is rights, there is also the responsibility that comes with the right per se. So it is timely, though it is a 2013 document. Very few people are aware of the Patients' Rights Charter, which to me then calls for more public participation and creation awareness of awareness by various stakeholders. I think that's what I can say as per now.
Thank you, Mr. Fleming. As you were doing your intro and giving us a bit of what it entails in legally and talking about the human rights, maybe you'll have an opportunity to tell us as healthcare workers or even as patients, because we have been once, or maybe some of us have been patients, whether there are times when human rights have been violated even as we provide care. But that opportunity will come as you'll be discussing somewhere there about dispute resolution. But the next question is to Dr. Esther Nafula. Just one of the rights is access to medical care and especially emergency care. Maybe make us understand or help us understand what this entails and what is the role of the healthcare worker where access to medical care is concerned, as far as emergency care is concerned. Dr. Esther.
Thank you. So the right to access health care is, first of all, every Kenyan has a right. Every Kenyan has a right to access promotive, preventive, curative, rehabilitative, and palliative care. And in emergency situations, patients are supposed to be stabilized by the institution. So if a patient presents in a healthcare facility in an emergency situation, whether they are able to pay for the treatment or not, they are meant to be stabilized first. So after stabilization, then at that point, can we then discuss now further care? Will the patient be admitted in that hospital or referred to another facility that is now able to continue with care? So the mandate of the healthcare facilities is to provide emergency care to stabilize the patient once they have presented to the facility. Thank you.
Thank you, Dr. Nafula. The issue of emergency care sometimes has been misunderstood, or maybe the patient is not aware up to what level. We have talked about the patient rights and the responsibilities. Dr. Fleming, maybe you can help us to draw the line where, after stabilization of the patient, maybe post RTA or post an emergency, and the patient is in a private facility and they're not able to pay for their care, then what does that mean to the patient and to the health care facility?
Now, allow me to first of all reiterate what Dr. Esther has talked about in terms of accessibility, which means that every health facility should be accessible to all without discrimination. Now, discrimination is on various bases. accessibility can be denied physically, economically, if the treatment is not affordable, and if the information is that or lacking. Now, regarding the emergency treatment, I think I'm the least qualified to define what emergency treatment is, because emergency treatment is circumstantial, depending on the situation and the status in which a patient is, for example, wheeled to your facility. But the biggest question is, a patient is wheeled in or brought in an ambulance, and you have assessed the situation. Whether you are a private facility or a public facility, you have the legal obligation, the very least, to administer treatment by way of stabilizing the patient. Now, once the patient is stabilized enough, then all other processes kicks in. And that brings me to various patients' rights. The right to the billing process, which also comes with the responsibility of paying all dues, perhaps timely as they fall due. But that in itself is not supposed to deny a patient the emergency treatment. As a clinician, as a doctor, as a health service provider, if it is in your judgment that the patient requires emergency intervention, whether payment is due or not, you are under legal obligation to administer the emergency intervention before calling for payments or the billing process. So that is a legal obligation that cannot be suspended by the mere fact that economically the service is not affordable. Now, there are other interventions that is available to the health facility to secure the outstanding hospital bills. For example, the patient may charge a property to secure the hospital bill. And you're also aware, by the way, that there are other responsibility or legislative interventions that have come, indicating that you cannot withhold, for example, you cannot detain a patient because of the outstanding medical bill. And also you cannot detain a cadaver or a body because there are pending bills. So allow me to say the long and short of it is, if it is in your judgment call that emergency medical treatment intervention is required, then you have no reason to withhold that particular treatment because the billing process has not been completed or the individual has not paid the required bill. That one, you will be violating the right of the patient to access the health services that offer. I think I'll end it at that.
Thank you, Mr. Fleming. I think that is quite clear. The question is, does the issue of payment arise? Or should we speak about money at the beginning of maybe offering the emergency care? Just like you said, the emergency care is circumstantial. I could come with an MI, not an RTA. Should we be speaking about money at that point? Maybe that is what.
There is nothing wrong in speaking about money or who is supposed to be meeting the hospital bills of the patient who requires the emergency treatment. Now, you have every right to access that particular information from the patient or the next of kin of the patient. The only thing that will be derogating the right of the patient is when you indicate that you are going to withhold the emergency treatment intervention until the relatives or the next of kin pay a certain sum of money. So that in itself will be denying access to the medical intervention that a patient requires. So you may ask, you may probe and prod the next of kin or even the relatives of the patient regarding the billing process, because it is the responsibility of the patient or the relatives of the patient to pay all dues in a timely manner and according to the hospital policy. But the hospital policy of receiving the medical bills or the money to defray the bills that have incurred does not supersede the rights anchored under the Patients' Rights Charter and also under the Constitution and other enabling legislative instruments. Those rights reign supreme over the hospital policy. So you can ask for that particular information, but you cannot deny a patient that particular medical intervention, which is an emergency based on the judgment call that you have made, because the patient is yet to pay the hospital bill or even the deposit that is required, whether you are a private or a public facility.
I think, yeah, also to add on that, remember that one of the responsibilities that has been stipulated for the patients is that they need to inquire about the costs of treatment and make appropriate arrangements for payment. Because sometimes in those emergency situations, there could be tests that are needed or scans that are needed to be able to actually give proper care to the patient. So in cases of a medical emergency, just as my colleague has said, the mandate of the hospital is to offer emergency care. So again, it is to assess what is the emergency, what interventions are needed to save the patient's life, and then what are the next steps. And I think the communication actually has to be done well to the relatives, because sometimes, like in cases of a road accident, you'll find the victims will be brought to the nearest facility to the accident site. So emergency care includes things like immobilizing fractured limbs, includes stopping bleeding, maybe giving some pain medication. But most often after the emergency interventions have been offered, then the issue of billing comes up, that now we might need to do more investigations to see the extent of injuries. So the question of affordability comes. And at that point, actually, the patient has a responsibility to make arrangements for the payment, or now to choose a healthcare facility where they can afford the care. I think that's what I can add on that. Thank you.
Thank you, Dr. Nafula, for that input. And I think the aspect of emergency care and access of care has been elaborated very well by Mr. Lumumba. Now, we talk about access to care, and sometimes we have issues that come up, people who cannot pay, people with disability, and here we will talk about access to care and the right to be given insurance cover. Mr. Fleming, help us with this to be able to understand how then we help whose responsibility is it to offer insurance coverage, giving information to the citizenry and to our patients, even as they come. Some of them come with no insurance cover, and our healthcare is not free. And so help us, how do we help our patients then to access care which is not free?
Now, first and foremost, it is important for the patient to realize and know that it is their right to receive a bill and an explanation as far as the hospital fees of any service is concerned. Now, that particular right comes with the responsibility of the patient or the family of the patient paying all dues that they have incurred at the hospital. So to the very least, the patient and the family of the patient, they are supposed to take steps in order to ensure that they lessen the burden of meeting the hospital bill by themselves. And that's why the insurance schemes have been brought on board, both private and public, in the name of the National Hospital Social Insurance Fund, which is now transitioning into a totally different outfit. Now, to indicate that there is need of more stakeholder engagements to sensitize the patients that the cost of treatment nowadays is skyrocketing, and the only way of lessening that burden is for every individual, every household to take steps and procure an insurance cover for themselves. Now, that is not to take away the responsibility of the government of the day in sensitizing the citizenry of their obligation and the existence of these insurance covers. Now, the hospitals as stakeholders and the health service providers as stakeholders equally have that responsibility of providing adequate information to the individuals as far as the billing is concerned, as far as the burden of billing is concerned, and how they can lessen that particular burden. Now, there are statutory interventions that have been put in place to lessen these particular burdens. Now, there are also those particular individuals who we call the indigents, who cannot afford, won't pay, can't pay. So the government is supposed to be brought into, or on board, I mean, to establish a fund for the indigents so that you do not just exhaust the resources of the hospital, but at least you allow them also to draw in from that fund to recoup whatever they have expended in service provision, health service provision to these particular indigents. I have come across instances where you have to seek pre-authorization from the NHIF so that they cater for those particular individuals. There are all these particular interventions that the government has come up with, the Linda Mama and all the initiatives that are geared towards lessening the burden of treatment. So the long short of the story is, as a patient, you have the primary duty to take up that particular burden of meeting your cost. And that includes taking up the insurance schemes, both the NHIF and also the private insurance covers for yourself.
Thank you. Thank you, Mr. Fleming. Dr. Nafula, would you like to add something?
No, not on that issue.
Not on that issue. The issue of right to insurance coverage is without discrimination, whether you're young or old, whether a pregnant woman, people living with disability, whatever illness, everybody has a right to have a cover. And therefore, as Mr. Fleming has said, the government of the day has the responsibility to sensitize its citizens on the importance of that. But also as healthcare workers, because we are also charged with educating the people who come to our facilities, then we also can shed a light on that and help our clients to be able to access a cover. Now, the next question will be to Dr. Nafula. Maybe you can expound more on the right to higher sustainable quality healthcare products and services, even in a resource limited environment where these products sometimes may be scarce, may be not available. An example is when the ICU beds are not many, and we have many patients who require ICU care. Dr. Nafula?
So yes, every patient has a right to the highest attainable quality of health care products and services. That means that it's the mandate of the government to ensure that whatever healthcare is needed, the citizens are able to access it or to attain it. So we know there has been a lot of issues around access to quality healthcare. Sometimes we have stockouts of medications, we have tests and scans or imaging that we need that are not available in some parts of the country. Again, the cost is an issue. But remember, patients' rights charters also help us to do some system evaluations and to help to improve the healthcare systems. So we might not be able to achieve this right as of now, but having a patient rights charter helps the government to also evaluate what rights does the patient actually have, what rights are being met and which ones are we not able to meet and why, and how can we intervene. So as we do the evaluations of the charter and the accessibility to the best quality of care, this charter will help our government to also know which areas to prioritize to ensure that that right is actually achieved for Kenyans. Thank you.
Thank you, Dr. Nafula. And coupled with that, highest attainable quality healthcare also comes with the type of healthcare providers we have. We will talk about maybe the regulatory bodies and what they need to do so that we can have the right skills and the right attitude, the right knowledge to be able to offer this high quality of healthcare. So the next question is almost the same, almost it's speaking to almost the same, where we have the patient has a right to information. Um, the question is, how much information should we give to our patients? When? How? And this, Dr. Nafula will help us to discuss this. Dr.
Yes, so every patient is entitled to receive full and accurate information about their health and healthcare. So it is our mandate as healthcare providers to communicate with patients about their diagnosis, the medical procedures that we want to carry on them, the treatment, medications we are going to give them, their prognosis of their illness, side effects of this medication. So sometimes in practice, we find that we are talking more to the relatives than the patient. You find a patient being treated even for a condition they are not aware they have. They do not know how long their treatment is going to take. They actually have no clue what is happening with their bodies. But it's their right. So before we even start sharing information with relatives, next of kins, guardians, we need to involve the patient. Now, the way we deliver information, that is a subject for another day, but we need to ensure that we give patients their full and accurate information about their health and the healthcare. So when we are, before even we make a diagnosis, when we are doing investigations, we need to let the patient know this is the kind of medical conditions that you might have, or these are the kind of diseases or diagnoses that we are investigating. These are the symptoms you've come up with. And once the results are back, we also need to discuss with them and tell them this is how the treatment is going to go. This is the kind of interventions that you need. This is the kind of rehabilitation. This is the kind of follow-up plan. And these are the healthcare facilities where you can access this care. It's also our responsibility to educate the patients about the available healthcare facilities in their locality. It is a responsibility of the patient to be aware of those available healthcare services, but even when we interact with them and we are helping them to make decisions or giving them information, we need to also tell them which other places they can access healthcare services. Thank you.
Thank you, Daktari. But just before you drop the mic, there is a question. Should admitted patients have right to safety? I've seen a question here. of course, there's another question about does emergency care in setting of stabilizing patients include radiological examinations? After stabilizing the patient, uh, do you refer if they cannot pay? Those are questions on the chat. Maybe the first two, Dr. you can talk about. Then Dr. Fleming will respond to after stabilizing the patient. Then do you refer if they cannot pay?
All right. So the first question was about right to safety.
Yes.
So, okay, our patient's right charter has not included right to safety, but some other patient rights charters have included that. And remember, also institutions can come up with their own patient's rights charter. So you can use the national charter to also derive rights and responsibilities of patients when they interact with your healthcare facility. So for now, safety was not included, but maybe when there is a revision, they might add more rights or at least enrich the ones that are there. Now, when it comes to emergency medical care, there is no blanket answer of actually what emergency medical care will entail because it is very subjective. It depends on the condition of the patient. It depends on a lot of things. And it also depends on the facility. Because for some facilities, these radiological investigations might be needed for emergency care, but if they are very expensive, you might find that they would prefer to move the patient to a public facility, where now in the public facility, it's our mandate to give all the care that exists, whether the patient is able to pay or not. So it is very difficult to say whether we should include the radiological investigations, but then emergency care, it's at the discretion of the healthcare provider to assess and see, because medical emergencies are defined as situations that are life-threatening. So it is to look and see what is the most crucial thing that can save this patient's life. And that's why I think the question of when to talk about money came up. It's actually inevitable you will have to talk about money when you're dealing with the emergency situations, because when you need investigations and the investigations have to be paid for, then you have to discuss with the relatives or with the patient so that you can look at what does stabilizing this patient mean before we move them now to a facility where we can afford. That's my input for now.
Thank you, Dr. Dr. Fleming, maybe should we then refer if someone cannot pay?
Now, generally, and the long short of it is that inability to pay is not one of the reasons for referral. Now, I'm speaking about it from the referral system perspective. You don't refer a patient, perhaps maybe for specialized treatment, upwards because they are not able to pay for that particular service. However, there are certain manner of doing it or a soft way of doing it. So at the risk of being quoted, don't misquote me or quote me elsewhere, you can a family conference and perhaps maybe do a cost benefit analysis of quote unquote the patient being there vis-a-vis the patient being at a certain hospital. So all this boils down to the information as far as the services are concerned, the information as far as the billing and the fees are concerned at your hospital vis-a-vis the place where you are referring them. Now, I don't know whether, for example, if hospital A admits a patient for emergency treatment, stabilizes him or her, then refers him. What will they be indicating in that particular letter? That we are referring you to hospital B because you are not able to pay. So I'm looking at it from that particular perspective. But there is a way of having a family conference and looking at their economic situation and rightly informing them of the efficient way of meeting the cost. if the services that they are due for are available at a cheaper, perhaps maybe at a cheaper cost at a different facility, then that particular information is very important to be accorded to either the patient or the family so that they can opt to go to that particular facility and receive the treatment on account of the relief associated with the cost. But you will not indicate in the referral letter that this patient is not able to pay. So who is that particular facility that is going to act pro bono because you have just transferred perhaps quote unquote a problem to them?
Thank you, Mr. Fleming. And I like the fact that you've asked what will be written in that referral letter. Is it a lack of money? Because the referral letter should be talking about maybe specialized care. And I also agree with you and like the fact that you've talked about a discussion happening with the family, holding a family conference, and let the patient, if they're able to make a choice, then they can make a choice at that point. And so it's a right to give information, and therefore the patient is able or the family is able to make an informed decision. Thank you very much for those questions that have come in. Keep them coming, but we'll continue with the discussion. Now, during care, conflicts do happen. A conflict between a healthcare provider and the patient or family. Dr. Nafula, help us in discussing this and understanding how we can identify conflict and how we can separate conflict from the actual care. How the healthcare provider then can be able to separate conflict from the actual care that they're supposed to be providing. Dr.
Yeah, all right. So disputes sometimes arise. Maybe the patient might not be happy with the service they've received, or they might feel that sometimes they feel that service was denied to them. So the conflicts need to be resolved in an amicable way. So where the patient lodges their complaint, I think is the first place to start. Because remember, during the presentation, I said that some patients go to complain on social media, some go to TV to complain. So I think before they even get there, we need some internal mechanisms of where patients complain and how are these complaints addressed, and if there's a dispute, how is it resolved? So within the institution, we need those internal mechanisms. Sometimes there's a committee that is established to look into the matter that is being complained about, and then some appropriate steps are taken to try and resolve the complaint conclusively to the satisfaction of all the concerned parties. So that would be that if a patient is dissatisfied with care, we try to find out why, what are the gaps that are making the patient dissatisfied with the care, and how can that be resolved for that patient and even for future patients. So sometimes this is easier said than done, because also with interaction with patients and the healthcare system, we know that a lot of blame is actually assigned to healthcare providers, even when they've done their best. There are many cases we can quote of patients who've come in and the patient has succumbed or the patient has got complications, and the blame is laid squarely on the healthcare providers that they did not do enough, they neglected our patient. And sometimes it's just a misunderstanding because, again, remember there's a right to information. So when we do not also give patients enough information about their diagnosis and the treatment and interventions, sometimes that leads to a dispute. So we can try to prevent disputes by giving proper, accurate, and timely information. And then now on the flip side, when there's a dispute, we can look at how to also resolve it amicably without defaming the character and names of doctors, nurses, physiotherapists, or hospitals that were actually just trying to help the individual. So again, I'll agree with both of you, Anne and Fleming, that there's a lot of sensitization that needs to be done to the public, because we are saying rights come with responsibilities. Now, the patient has a right, the healthcare provider has a right. We'll probably discuss rights of healthcare providers in another forum. The institution has a right, they have a mandate, then there's responsibilities. So it's just to try and get all parties to understand and resolve the dispute. Thank you.
Thank you, Daktari. On the same note, we are asking what legal channels do we have, Mr. Fleming, when a dispute occurs? Do we have any provisions for dispute resolution, either by our regulatory bodies? Can someone just walk in there and say, I have had this problem and no one listened to me? How do we go about it? And even for our healthcare providers to know that they can also help the patients and the families if they are dissatisfied, what channels are there for them to raise those concerns? Mr. Fleming?
Uh, Now, just speaking from where Dr. Nafula has left, it is important to note that the relationship that we have with our patients, with our employers, normally is a breeding ground for various forms of dispute. Now, the Constitution recognizes various ways of resolving this particular dispute. Now, we need to give primary focus or emphasis on the alternative forms of dispute resolution, which has not taken root majorly in the health sector. For example, there is a new form of dispute resolution that is coming in the form of mediation. You mediate any dispute that has happened before it escalates to the regulatory bodies. When dispute escalates to regulatory bodies, there are various consequences which are far-reaching, both on the institution and the individual service provider or the healthcare service provider, which may even include the individual health service provider being struck off the role of the professional, depending on which profession you profess, or even the health institution being deregistered, which is very dire. So before the dispute crystallizes, it is important to approach the disputing parties to come to a table of mediation where they highlight their issues that can be sorted out. It is also important to indicate that at the very least, communication is very key in terms of addressing the dispute. So most of the dispute that ends up in these regulatory bodies, some of them are because of miscommunication or misinformation, which can ultimately be avoided when parties communicate rightly and through the right channel, and providing adequate information to the individuals in need of such information. So yes, dispute normally arise, especially when rights and responsibilities that are tied to them are not adhered to or are breached. Now, in instances of regulatory bodies, we have various bodies that have been instituted by way of legislative instruments, such as we have the Medical Council, which comes under the Medical Practitioners and Dentists Board Act. We have also the Pharmacy Poisons Board. We have the Nursing Council of Kenya, the Clinical Officers Council. All these particular regulatory bodies regulate the conduct of their members in the provision of healthcare service. So if there is a breach, the patient is entitled to for example, bring that particular health service provider to that particular body or the institution or the hospital to that particular body to have that particular breach addressed. In the event that they are dissatisfied again, they have the courts through which they can seek redress.
Thank you, Mr. Fleming. I like the part that you have talked about identifying that dispute and trying to address it before it escalates even to the regulatory body. So we have a responsibility in our own health setup to have dispute resolution mechanism, and of course the healthcare workers being able to identify how then to handle these issues before they escalate and before it becomes nasty and then we find ourselves in the social media. Going forward, we will have another question from the chat, and this question is to Dr. Nafula, and you will answer it with the other question on issues of consent, consent for competent patients, how you administer consent, and if a patient is not competent, then how do you go about it? And so the question here is, do healthcare workers have a right to consent for a patient, for example, in an event of an emergency, or the patient and the relatives are making the wrong decision or choice? Dr. Nafula.
So it's asking about, the participant wants to know whether we can consent on behalf of the patient.
Yes, in the event of an emergency, or where the relatives, you in your own opinion, in the opinion of the healthcare giver, that the decision or the choice is wrong for the patient.
So I think, again, when it comes to issues of choice of treatment, informed decision-making means we give them information and help them to make a good decision. In cases of emergency, many of our facilities have hospital ethics committees that can be able to evaluate the situation. And I think the internal policies allow for consent from two consultants for medical procedures, especially for surgeries that are emergency cases, but that has to go through the proper channels again. Remember, we are trying to avoid disputes of I refuse this treatment and it was still given to me anyway. We've had cases where people have been amputated to save their lives, but after the amputation, they're not happy about it. Yes, they're alive, but they feel I never consented for that treatment. So to avoid that, we need to involve, where possible, the ethics committees or the healthcare providers or the teams that are dealing with ethical dilemmas within the institution, so that the emergency care can be given, but also we consider what are the likely issues that may arise from that, and how do we try to ensure that there is no dispute at the end. What was the other question?
The other question now is about consent for competent patient and versus incompetent patient. A patient who can give consent and one who may not be able to give consent.
All right.
Or
So
when
in
a
the
patient
same,
is not able
yes.
to, sorry, when a patient
In
is
the
not able
same,
to make decisions.
yes, to make decisions. In the same patient's rights charter, it stipulates that when we have a minor or we have a patient who is not competent to make decisions, where applicable, a next of kin or guardian should offer protection and care to the patient, and that includes making decisions for them. So we assess the situation and we have evidence that this person is incompetent. Either they have a mental problem or they are comatose or they are a minor, they cannot make decisions. Then it's to look at who now has that responsibility. Is it a parent, a guardian, a next of kin, or a medical proxy to make decisions for them? Thank you.
Thank you, Dr. There is an issue of when, for example, an elderly patient is in hospital and maybe a life-changing diagnosis has been made. The family may feel let us protect our grandma or grandfather from distress. And so the doctor is asked by the family, please um, don't give that information to the patient because it is.
Mm.
What is your
That
feeling
is
about?
that is a common scenario, and actually research has been done, and it is called conspiracy of silence, where the healthcare provider conspires with the relatives to withhold information from a patient. It is unethical because the patient has a right to make their own decisions. The patient has a right to information. So it is unethical and it is not right. Where a patient is sound of mind, we need to deal with the patient first. We need to give the information to the patient first before we start dealing with the relatives. And even when the relatives ask you to withhold the information, please, you need to sit with them, uh, take them through what the rights of the patient are and why it is important that the patient should be involved in their own care, because we are practicing medicine and nursing and healthcare fields with an aim of patient-centered care. And we cannot have patient-centered care when we are not communicating with the patient. So it is important that you explain to the relatives and try to address their concerns and let them know why it is important for the patient to know about their diagnosis. And in the cases where the patient does not speak your language or you do not speak the patient's language, there's a language barrier. Always get a translator who is a neutral person, either from the healthcare staff, so that they can translate appropriately. Because again, if you are going to translate with relatives who have already told you to withhold information, they'll translate their own things to the patient. Thank you.
Thank you for that. Well, you have answered that question very well. Um, there is always need to give information and give the correct information, and where family feels that they have not understood, hold as many family conferences as possible for people to be able to understand, and then they can make the right decisions for their families and for themselves, for their patients and for themselves. There's another question on the chat, and this one will go to Mr. Fleming. Who holds the government accountable to ensure that public facilities are well equipped to give the best care the patient requires?
Now, first and foremost, as a citizen, you have to hold the government to account for all its action, uh, based on the leaders you elect and based on the policies that are being put in place to ensure some of these aspirations are realized. Secondly, they are the representatives of the people in the name of the members of the parliament, that is National Assembly, Senate, or even the members of the county assemblies. Now, thirdly, there is the non-governmental institutions, and there is also in fact, let me just put it this way. Every stakeholder has a responsibility of holding the government to account based on the promises they make and based on the statutory obligations that they are supposed to implement for the realization of quality healthcare service provision. There is no way about it. You and I have that particular responsibility. First, by our actions of appointing the right leadership to the various places of responsibilities. That is the highest call of responsibility of the citizenry. The rest of the chips will just fall into place.
Oh, thank you very much, Mr. Fleming. The responsibility is on us as citizens. Now, there's another question, and this one is about uh, when a healthcare worker is maybe slapped or beaten by a client, what happens, Mr. Fleming?
First and foremost, physical assault is criminal in nature. So there is a need, one, to report such particular assaults to the relevant authorities in order for the law to take its course. Then other than that, there is also, how can I put it? There's also, there's nothing that, that warrants an individual to attack a health service provider. If there is violence at workplace, then it indicates that the individual or not just the employees or the health service providers that are at risk. So the employer, first of all, has the responsibility of ensuring that the workplace is safe for work. And safe for work also includes providing security and safety measures, both for the patient and the healthcare workers. In the event of the breach, there are protocols and SOPs to be followed in order to address the situation as they unfold. But the responsibility of a safe working environment falls on the employer. That's why you find most hospitals would employ security guards. Most hospitals would employ, would install CCTV cameras. These are just mechanisms of ensuring that the workplace is safe. In the event of such particular assaults, then now the individual assaulted should be dealt with in accordance with the law. But there are also instances of a mental health situation that would force either an employee or even a patient to act in such a manner. Do we look at issues surrounding the mental health in order to determine the wholesomeness or the how can I, a holistic well-being of the employee and that of the employer. So safety work environment is a broader perspective that both the employer and the employee has a role to play.
Thank you very much, Mr. Fleming. The question also continues to ask, should we then deny this person the care, or if it is on behalf of a patient, should we deny the patient or the family the services that they are coming to seek, since they've become hostile, they are sorting everybody?
Remember, the person who is seeking service is the patient, not the relative of the patient. Now, there are people who have higher propensity to annoyance. The mere fact that a nurse does not smile already has annoyed some of the individuals, or even the personal demeanor, the strictness. Like, for example, if there is controlled area, controlled access, some of the family or the relatives may not take that lightly. So the mere fact that a family is rude to you or has assaulted you does not obligate you to deny service to the patient who is in need. That is a totally unrelated event that should be dealt with through the legal channels and the security channels that are provided for within the institution.
Very well. Thank you, Mr. Fleming. There's another question that is tied to the consent, but this one is a question in regard to in the event that a parent or a guardian, against your expert opinion, has refused or declined treatment on behalf of a child. So where do we draw the line here, Dr. Nafula?
Okay, so the first thing is to evaluate the treatment that is being rejected. Is it a life-saving treatment? Is it going to change the prognosis of the child or not? Because sometimes we have forced parents, I'm using that word forced loosely. We have forced parents to consent for treatment, and then the outcome is still negative. Sometimes the child still complicates or dies from their illness, yet we had forced them to get a treatment. So it is good first to evaluate what is the overall prognosis of the child, and then what is the benefit of this treatment that we are advocating for, and what are the reasons for the parents refusing the treatment. So if we have a family conference with the parents, we explain to them and they still reject the treatment, but in our expert opinion, this treatment is life-saving, then we can pursue the legal channel through the courts to allow us to give the treatment. Thank you.
Thank you, Dr. Nafula. There's a very interesting question here, Mr. Fleming. This one goes to you. At what point is a healthcare provider allowed to violate the right of a patient? What if the patient wants to commit suicide? Should we deny by denying himself life-saving medication or operation?
Now, one, in instances of a patient refusing treatment, I think there are protocols and SOPs at every institution where you have to document the reasons and perhaps maybe indicate.
Hi, Fleming, are you there or you dropped off? I think Mr. Fleming
I think maybe his connection is bad. Yeah.
yeah. There's another question that has come in here, Dr. Nafula, as we wait for Mr. Fleming to come in. There is someone who is saying, great presentation, but the practice of things don't work as it said. People have lost jobs. They've been surcharged for offering treatment in absence of evidence of ability to pay. And so employees feel that their hands are tied sometimes to offer stabilization, then advise the client for referral. Yes, Mr. Fleming, you're back.
Yes.
You may want to finish your point.
No, I thought I'd finished, or it cut me through.
It cut you.
Oh, okay. Now, remind me, what was the question? Because I got while you are, so I was just thinking.
Yeah, the question was about when the healthcare worker is allowed to violate the patient's rights.
Okay.
Yes.
Now, I was pointing out first and foremost, there are instances where an adult patient can refuse treatment. Now, the primary doctor or the doctor in charge of the health service provider is allowed to document and perhaps indicate discharge against medical advice and the circumstances. Now, the counseling process should be allowed to take place and to document all these particular instances. I think by the time my internet was interrupted, or I was indicating that Kenyans, and especially the patients and their families, are litigious. And recently, there is an increase in the number of medical legal cases. Now, some of those particular medical legal cases are to the extent of withholding treatment and that information and that has been captured in the patient file. So just to protect yourself as a medical service provider, it is important to document this particular information and steps clearly and in a complete manner, such that a third party reading that particular patient file is able to tell that despite all this particular interventions, the individual refused treatment. Now, secondly, there are instances where even if you refuse treatment, for example, if we are talking about those particular communicable diseases that are able to, for example, to spiral to the effect of causing a pandemic within the country or a locality, even if the individual is to repeat or was to refuse treatment, the medical service providers are still under obligation to treat and contain the ailment, because there is the public interest that is being taken into perspective. And the other aspect also involves situations where we have parents refusing treatment, transfusion because of cultural beliefs or religious beliefs that they profess while projecting it on the minors. Just like Dr. Nafula indicated, all these other interventions, family conferences, they are ideally good and meant to bring you into the perspective of the expert opinion. But in the absence of you not coming into an agreement with the expert opinion, then a child is a property of the state, to put it that way. You cannot, as a parent, stop a child from receiving that particular kind of treatment. So even in those particular circumstances, the doctor and the institution is still mandated, whether you withhold it or refuse treatment, the medical service providers are still mandated to subject the child to treatment interventions.
Very well, thank you, Mr. Fleming. And we were looking at one of the other questions, but maybe you can answer this one about the technology. Someone is asking, how do new technologies such as genetic testing and artificial intelligence impact patients' rights? Who owns and controls patients' data collected through these technologies? How can we ensure that the technologies are used ethically in the best interest of the patient?
I think in terms of regulating technology, it is important for us to, or the medical profession, to begin relooking at the mandate and the mandate of the regulatory bodies, especially as far as technology is concerned. Because truth be told, technology has advanced medical practice and intervention in the life of the patient, much to the advantage side. But equally, the technology can also be misused by various institutions. For example, the pharmaceutical industries and mostly pharmaceutical industries, in terms of data mining, in order to look at what is the future projections in addressing either the inadequacies in the medical field, which can be to the advantage. And again, also when that particular data is misused, it can also be to the disadvantage. Now, this brings me to the new regulations or the new Act of Parliament that came into force, that is the data protection. It is important because the Data Protection Act mandates the individuals who handle data to register as a data processor or data handler, depending on your role. So one way of regulating the mining of data or the management of data is the registration process that is conducted by the Data Commissioner. Now, you have seen instances where individuals who have misused data, leave alone the health data, that just the general data, being fined and to an extent also being warned from misusing that particular data. Now, there is also the latest communication from the Office of Data Commissioner that also speaks on how health data is supposed to be handled. Now, this is a novel area that is still undergoing a lot of fine-tuning, policy-wise and also through the legislative instrument, because we are just now looking at to what extent can the Data Act protect the individuals from the abusers of the data itself. So this is a novel province that still is undergoing a lot of fine-tuning, especially when it comes to health data. And that is used to undermine the importance of data in the medical field. But the health data is also at risk of being misused by multinational companies, and for which the mandate of the data commissioner can also be called into action to investigate those particular breaches of violations.
Thank you, Fleming. And the issue of healthcare workers' use of social media, WhatsApp, to communicate about a certain, or maybe we are told telemedicine, and maybe the systems have not been put in place, but you want to discuss something um, with your colleagues, maybe to seek clarification or something. Does that lie under Data Protection Act, or
Yes,
what would you say?
And under the Data Protection Act, for example, you have colleagues away from work that you need to consult, and you take a photo of the patient and quickly share it. One, quickly share it to the forum of doctors or nurses.
He's gone again. Sorry about that.
Are able to manipulate it. And
Okay.
secondly, the individual patient has not given you the right to share his or her information. Now, with that in mind, there are ways through which you are still able to share the same information, consult on the same information by way of reducing the identifiable features of the patient in question. Like, for example, if you wanted to consult about me or about me with your colleagues, for example, you are supposed to limit the data you are sharing to the extent that you, Anne, is not able to identify that the patient that we are speaking about is Fleming Omondi, you see? So you are reducing the identifiable features by way of limiting the interaction of the third parties with the specific patient in question. So you are still able to consult on the issue, but also protect the patient's privacy, because privacy is also a principle. Dignity of the patient is also a principle. So in sharing all this, you still have to preserve that particular identity of the patient.
Thank you very much. Before we look at the chat for another question, there is the question of the right for the patient or the family to complain, to raise concern, or to even point out that they are not satisfied with our services. Dr. Nafula, how do we go about handling complaints against us as healthcare workers? And what channels are there? I know we spoke about the channels, but at individual level, how should we handle a complaint leveled against us as healthcare givers?
I think first is to acknowledge that the relative is dissatisfied with the care, and again to try and pick out why they're dissatisfied. So it's just the same principles of resolving disputes, that we try to get to the same page amicably. That might not be easy. It might be easier said than done. But again, internally within our facilities, we need to develop our patient rights charter for the institution that can also give those channels in written, that if you have a complaint, this is the department that will address your complaint, or this is the channel to use within this institution to get your dispute resolved or to get your complaints heard. Thank you.
Thank you very much. I would like to add also on to what Dr. Aya said, that one, yes, acknowledge and then appreciate that even that feedback has come, because then when patients complain, they're not complaining sometimes on behalf of themselves, but also they are pointing out something that is not working out well. And so objectively look into our processes, look into the system, and provide improvement. And I think we can have the last question about the safety of the patient. There's someone who is saying, I have asked about the safety of the patient, because some relatives have brought food to patients, and sometimes poisonous food or poisoned food, and they have deteriorated or they've gotten adverse reaction. The issue of patient safety again has come up, and this one, as I will reiterate what Mr. Fleming said, that the institution has the responsibility to make sure that the environment is safe, not only for the patient, but also for the healthcare workers. But in the event that a patient has received something that is not good for their health, Dr. Nafula, what would you advise the healthcare workers to do?
That the patient has received, sorry, I didn't catch the last bit.
They received some food stuff that was quote unquote poisoned, and now the patient has deteriorated. Yeah, how should we handle such an issue?
I think that again, it's just about communication. I think I'm not understanding the question as to maybe where the poisoning, has the patient been admitted after being poisoned, or this patient has been poisoned within an institution?
Okay, let me read it verbatim.
Yes.
She's saying, I'm asking about the safety of the patient because a relative visits a patient and gives her poisoned oranges. The patient is now on dialysis.
So yeah, now remember Fleming had mentioned the issues of security. So
Yes.
the hospital or institutions have their own mechanisms to try and ensure patient safety. So again, that's an issue that will be handled from, of course, medically, we have to treat the patient, but then now we need to look at the security breaches and how to ensure that when patients are within the institution, because they are within our custody, that they're actually safe, and whatever they consume, be it food, drinks, medication, is safe for them. And hence why many hospitals restrict food from outside when a patient is admitted, to try and curb those kind of problems. Thank you.
Thank you very much, Daktari. I think you've answered that question very well. Finally, where we are testing patients for HIV without their knowledge, without their consent. This one we can have both Fleming and Daktari respond to it.
I think I can respond first. When it
Yeah.
comes to HIV, there's provision for provider-initiated testing and counseling. That means that as the healthcare provider, we feel it is important that this patient be tested for HIV, maybe because of the lab results or the way the patient has presented, and we initiate the testing. But it's supposed to be followed by counseling after the results come. Now, in an ideal setup, it would be good to let the patient know that you would like to test them and receive their consent. Sometimes you do not have the consent, but that result is going to change your approach to the treatment. That's why there is provision for provider-initiated testing and counseling. So that's the input I can give, that from our side, we can initiate the testing, and sometimes, yes, we've tested without the consent, but then we need to now look at the approach of how to break the news to the patient and how to support them after the testing. Fleming?
I think from my perspective, you've handled it well, and there's nothing much to add.
Thank you very much, Fleming. Maybe you can give your parting shot as we call it a day, because our time is far much gone. Maybe you can give your last contribution.
Yes.
Daktari, go first.
On my side, I think I cannot emphasize enough that there is need for all healthcare providers or institutions that are providing healthcare to look at this patient rights charter, come up with institutional patient rights charter, educate patients and the healthcare providers on what these rights and responsibilities are. And also, as I end as the chair of the Hospital Ethics Committee, our next webinar will be about ethical issues that arise during renal transplantation. And we hope that you'll be able to join us in the month of February. Thank you.
Thank you, Daktari. You may go, Fleming.
I think it's it's not wise for me to water down what my chair has indicated. I think it sums everything as pertaining to patient rights charter. And
thank you very much. Thank you for your time, finding time to join us, and especially for our facilitators, our panelists, for finding time to come and share with us knowledge on patient rights charter. What has come out is that we all need to be to appraise ourselves on the rights of the patient, the responsibilities of the patient, and when the rights are violated or when a patient has felt that they have not been treated well, there are channels of how to handle that. Thank you very much for joining us. And as my chair has said, let us see you again next month, February. Thank you very much. Bye-bye.